for London West.
Thank you very much, Speaker. I'm pleased to have this opportunity to rise in this House and speak on Bill 49, the Ontario Immigration Act, on behalf of the people I represent in London West. I first want to recognize my colleague, the MPP for London Fanshawe, who's not in the House today, but was in the House earlier and has done some important work on this bill as the immigration critic for the NDP caucus. When she spoke to Bill 49, she did an exemplary job identifying some of the concerns that New Democrats have about this bill and some of the areas where we see room for improvement. As provincial representatives for the City of London, the member for London Fanshawe and I are both very much aware of the importance of immigration in building a strong local economy and ensuring a vibrant, diverse and inclusive city. We are also aware of the human costs of not adequately supporting immigrants once they arrive in our community. The member from London Fanshawe shared an email she had received from an internationally educated engineer who was frustrated and discouraged about not being able to enter his profession in London. In my comments on this legislation when I spoke to it in the last Parliament, I also shared stories from constituents in London West, similar stories of internationally trained physicians who were losing hope about ever being able to practice the specialized skills they spent years training for. These constituents are at the point of leaving London, maybe even leaving Ontario. They are telling other professionals from their home countries not to come to Canada, telling them they will not be able to find work in their chosen profession. This is hardly the kind of positive word of mouth that is going to encourage more immigrants to come to Ontario. So it's heartening that MPPs are debating this bill. The bill makes a strong statement about the value of immigration to Ontario. It includes a commitment to francophone immigration. It specifically recognizes the importance of family and humanitarian commitments, and it recognizes municipalities and employers as important partners. All of this is positive and encouraging, and as the MPP for London West, I can tell you that the fact we are talking about immigration is important to my community. It helps support London's efforts to enhance our reputation as a welcoming community and to strengthen our capacity to provide settlement and integration services. These efforts are being led by an amazing collaboration between the City of London and the United Way in the London and Middlesex Local Immigration Partnership, or LIP. Many of you have LIPs in your communities. They are federally funded bodies established to enable local engagement in immigration settlement and integration. They support collaboration and coordination across sectors and community partners, many of which are provincially funded. They also lead a process of strategic planning at the local level. Evaluation of the LIP model is validating the success of this approach, demonstrating the value of engaging all stakeholders in local planning and implementation. It is also positioning the work that is being done by the London and Middlesex LIP as best practice across the province and even the country. And certainly we know as a province that we have to learn from best practice and do something to increase our share of immigrants to Ontario. Between 2001 and 2011, Ontario's proportion of immigrants declined from 60% to 40%, which is Ontario's lowest share of immigrants in at least 30 years. In particular, Ontario's share of economic immigrants has significantly declined to the point where economic immigrants make up only half of all immigrants to Ontario, lower than any other province. In my community of London, we have identified the attraction and retention of newcomers as a high priority. The 2011 National Household Survey showed that London lost as many immigrants as we gained. London is also less diverse than the rest of the province. Immigrants make up only 22% of our population compared to 29% across Ontario. The makeup of our immigrant population is also quite different from the rest of Ontario. Our two largest ethnic groups are Spanish-speaking French-speaking immigrants and Arabic-speaking immigrants. Many bring pre-arrival experiences of war or trauma, even those who do not arrive as refugees. London is often a preferred secondary destination for immigrants after they have arrived in Toronto and is a primary destination for many refugees. But whether they are economic immigrants, refugees, or family-sponsored immigrants, newcomers to London face significant barriers. Last fall, London's Vital Signs report was released. It showed that the rate of unemployment among recent immigrants to London, those who had arrived within the last 5 years, was almost 20% in 2011, compared to 8.5% for non-immigrants. Half of all immigrant households live below the poverty line. We know that immigration is critical to our economic and social well-being as a community and as a province, and we therefore have an obligation to make sure that the services are there to welcome and support newcomers when they arrive. We need caring and compassionate services, culturally competent services, especially for refugees, those who are fleeing persecution from their home countries or have experienced war or trauma. I'm proud of the work that is being done in London, for example, with the Muslim Resource Centre for Social Support and Integration, an organization that has garnered national attention for its culturally responsive and evidence-based programming. Like so many other agencies, however, the MRC SSI struggles for funding to stay afloat, despite the significant need it is meeting in our community. I'm now going to turn to a summary of the main provisions of Bill 49 and then focus on some of the issues that are not addressed but must be taken into consideration as the province moves forward. First, Bill 49 enshrines into law the province's authority to establish and govern settlement programs for both temporary and permanent immigrants, and also gives the ministry the power to set targets for the number and type of immigrants to Ontario with selection criteria that meet provincial, economic and labour market needs. This sounds like a major change. However, it is important to note that the federal government would have to approve any new programs and targets, and there is no guarantee that this will happen. While Ontario has been able to attract some immigrants under the provincial nominee program, Ontario's share has historically been very small. Second, the bill enables the minister to conduct research, organize education and training programs, and appoint committees on immigration-related issues. This is a vital aspect of the bill because we need to understand what programs are working, how they are working, and how we can improve. Third, the bill allows the minister to establish registries for both employers and recruiters who are interested in participating in Ontario selection programs. This employer registry is similar to that currently in place in Manitoba for those who hire migrant workers from overseas, and the recruiter registry aligns with the new protections that were passed earlier this session. A disappointing omission is that the bill does not require employment agencies and recruiters to register, which is something we would have liked to see given the stories we've all heard about unscrupulous recruiters and the exploitation of foreign workers. There is also a lack of clarity about the role of the federal government, since employers must apply directly to the federal government to recruit migrant workers. And there is the omission of lawyers and consultants and anyone else who provides employment, guidance, advice, placement, or any other kind of recruitment services for newcomers. These professionals are absent or excluded from the registry. Fourth, the bill sets out a number of provisions related to process, new measures to monitor and detect possible contraventions of the Act, new powers for the minister to collect, use and disclose personal information, and a new compliance and enforcement regime, including inspection, investigation powers, offences and penalties for both individuals and organizations. The bill also establishes regulatory authority in areas such as program administration, eligibility, compliance, internal review, and the payment of fines. Finally, the bill aligns requirements under the Regulated Health Professions Act with those in the Fair Access to Regulated Professions and Compulsory Trades Act to improve the ability of internationally educated health professionals to enter their profession and to require timely decision-making, transparency of records, and reasonable application fees. As the NDP critic for training colleges and universities, I now want to focus on some issues related to post-secondary education that are not identified in the bill but must be addressed as the federal government proceeds with its new express entry immigration process, which will definitely have an impact on how we do things in Ontario. First, there is a concern that federal changes to immigration may make it more difficult for international students who have recently graduated from Canadian universities to qualify for permanent residence. Under the old system, international students with Canadian work experience were given priority status when they applied for permanent residence, and thousands of students have stayed in Canada and Ontario as a result. Relatively open access to permanent residence has been a significant advantage for Ontario colleges and universities in their international student recruitment efforts. Many institutions have developed comprehensive infrastructure to support their international recruitment initiatives. As of January of this year, however, the new system of express entry will place international students who have a degree or diploma from a Canadian institution in a pool with all other skilled workers. There, they may be invited to apply for permanent residence if there is no Canadian qualified to do the job, but will have to compete on points with skilled workers who may have many years of experience. Currently, international students make up the majority of Ontario's 2,500 provincial nominee program spots. Under the new rules, they will still be able to apply for permanent residence through the provincial nominee program and are therefore likely to make up an even greater proportion of provincial nominee immigrants, given the competition they're going to face in the express entry pool. The focus on economic class immigrants and the increased provincial nominee program targets that are included in Bill 49 thus shifts responsibility for settlement service provision away from government and gives it over to employers and post-secondary institutions. Since employers and post-secondary institutions have not traditionally been involved in settlement service delivery and may have limited experience in ensuring appropriate services, concerns have been raised about the quality of service provision. When immigrants are not effectively integrated into the local community, they may decide to move their families elsewhere, including to another province, which defeats one of the main purposes of the provincial nominee program. This shift in the provision of settlement services also raises policy implications about funding and about the ability of employers and post-secondary institutions to deliver comprehensive settlement supports. And at the same time we're seeing this shift, there are also calls from the Ontario Chamber of Commerce for colleges and universities to expand recruitment initiatives aimed at international students. The Chamber is calling on the government to modify eligibility requirements and the provincial funding formula to allow international students and graduates to access all provincial newcomer settlement and labour market integration programs and ensure that adequate funding is provided to meet the increase in services. The second issue that's relevant to my critic portfolio concerns bridging programs for internationally educated professionals. These programs help internationally educated newcomers adjust to the Canadian context and address any gaps in the competencies or skills they require to practice in Ontario. These are often delivered in post-secondary institutions. Just last month, the Fairness Commissioner issued her 2015 report and highlighted persistent problems that create barriers to internationally educated professionals entering practice. These include issues around the fairness of registration requirements, quality of assessments, registration decisions, and access to records. And some of these issues are going to be addressed in Bill 49. However, many of the issues she identifies will not. Her report called on regulatory bodies to justify the necessity of all requirements for registration, including the requirement for Canadian work experience. This is often the biggest, most insurmountable barrier that an immigrant faces. And it was also found in 2013 to be discriminatory by the Ontario Human Rights Commission. And the Ontario Human Rights Commission has actually passed a policy that calls calls on regulators to remove the Canadian experience requirement except for very rare circumstances. The policy states that employers and regulatory bodies must ask about all of a job applicant's previous work and not where they got their experience. The Fairness Commissioner's January report also includes some other recommendations, in particular sustainable funding for bridging programs. The report points out that bridging programs are highly dependent on project funding from the Ministry of Citizenship and Ministry of Training Colleges and Universities. Recognizing that fees to participate in these programs are often quite prohibitive, the ability of internationally educated professionals to participate can be limited. The Commissioner encouraged the expansion of the Ontario Bridging Participant Assistance Program, or OBAP, to enable more internationally educated professionals to access bridging. One example, it costs about $12,000 for the internationally educated nursing program. OBAP provides only $5,000 to help offset the bridging program tuition, so you can see that this would present a real barrier to an internationally educated nurse. I wanted to make a couple of additional comments about the bill, particularly in light of my role as NDP critic for women's issues. The Ontario Council of Agencies Serving Immigrants pointed out that the programs that Ontario funds for settlement and integration programs is small. However, these programs form a critical component of the service continuum and provide opportunity to meet the needs of and underserved groups. This, I would say, is or women are clearly an underserved group in the settlement sector or the immigrant serving sector. The Bill 49 is silent on the role of the community-based nonprofit immigrant and refugee serving sector, which we see as a concern. The sector is, some of the agencies involved in the sector are doing some great work to apply a gender lens to the immigrant experience. We know that males are more likely than women to be economic class immigrants, and female spouses are much more likely to be family-sponsored immigrants than male spouses. So sponsored individuals are highly vulnerable because of their uncertain legal status in Canada, which depends on having an ongoing positive relationship with their sponsor. If the relationship breaks down, sponsored women may feel that they are unable to leave their home. If they experience violence or abuse, the risks of reporting the violence are enormous because of fear of deportation. There has been research conducted showing that sponsored women who have not obtained permanent residency status are systematically isolated and excluded from society. They are often home with their children, not eligible to participate in the former labour market, no access to language training or other settlement programming, not eligible for social assistance. So organizations at the community level, like OCASI, play a vital role in sensitizing settlement workers to the unique experiences of immigrant women. In closing, Speaker, while we appreciate the intent of Bill 49 on this side of the House, we are also concerned that the legislation does not address some of the real and fundamental challenges facing newcomers to our province, some of the challenges I spoke of earlier. It does not address the long-standing problems of ensuring that highly trained immigrants are able to work in their professional field and that they find employment that matches their experience and can earn incomes that are in line with those of other similarly educated Ontarians. It does not deal with settlement issues such as housing, education, healthcare, and a myriad of other issues. It does not address issues that affect non-economic class immigrants, refugees, and family-sponsored immigrants, including their ability to enter the labour force. These are issues that did not just appear on the government's policy agenda this year or last year when the bill was first introduced. These are issues that we have been hearing about for years and years in this province. We are glad that the legislation has finally been brought forward. We are glad that we are talking about immigration in this place because we recognize the importance of immigration to our shared economic and social prosperity. However, we are disappointed that the Liberal government did not act sooner to bring this forward. After more than a decade in office, it's time that immigration legislation is being discussed. Thank you, Speaker.